Welcome to the Virtual Center for the Study of the Constitution of the United States. The Executive Director for the Virtual Center is Dr. Bill O'Brien. He's also your host. And here he is, Dr. Bill O'Brien.
The Virtual Center for the Study of the Constitution. This is Bill O'Brien, and it is a pleasure to be with you on this, a Tuesday afternoon. We are in our second program of this week, and it is a pleasure to be with you, as it always is. I just wanted to take a moment to acknowledge what all the media is covering right now, which is the horrendous tornado damage in Oklahoma, in and around Oklahoma City, and specifically in Moore, Oklahoma. And if there's any good news out of this, it's that the original death toll of 51 was cut back to 24. So far, we might, that's the most positive aspect of this. But if you've watched some of the videos and some of the aerial photos of that area that's devastated by a tornado, literally that was a half a mile wide, it's just absolutely impossible to even imagine the devastation. It's just unbelievable. And all I could think of is, what would you do in that kind of a situation? I mean, obviously you couldn't do anything by yourself. You'd need an awful lot of help. And I'm guessing that people seem to be coming forward. But the fact of the matter is, it seems like we're having one issue after another, and you wonder, there are still people out there that are questioning whether in fact we're doing damage to the environment. And I would suggest to you the severity of our weather is an indication that we are going through some sort of climate change experience. Now, whether it's a natural evolution in the history of the universe, as some of the conservatives want us to believe, or whether it's in part what we're doing to the environment, as many of our scientists are basically suggesting. You may be aware of the report last week that we had more carbon dioxide in the air currently than we've had in millions in more than 2 million years. So in a sense, something is happening. And the ice caps are melting, and the temperatures are increasing. The temperature of our water is increasing, our oceans. And the severity of our storms is incredible. Now, whether in fact we're causing it, whether in fact it's some part of the universal laws of the universe that we really don't understand, I rather suggest that cause is not really the issue now, because we may have waited so long that even if we are responsible, there's not a whole lot we can do about it, except maybe stop doing what we're doing. But even then, it may be too late for us for a while. But the point is, I think we need to at least acknowledge the devastation and the pain that so many of our fellow citizens are experiencing. And the fact that this involved a school and that there were so many children involved, I think is devastating. It's just hard to comprehend that kind of devastation, and surviving and recovering and getting back on your feet after that. And if there's anybody tuned into our program today from that area, all I want them to know is that all of us, and I'm sure I speak for everybody who's tuned in, all of us are keeping these people in our prayers, and we hope that not that things are going to be all right, because they're obviously not going to be all right, but hopefully they'll be able to weather it and get through it. It is a pleasure, as I mentioned, to be with you again today. Let me begin, as we always do, with our phone number and my personal email address. The phone number here, if you'd like to call in and get on the air and have the opportunity to share your ideas and your questions and your considerations or suggestions, or whatever point you would like to make on the issues that we're talking about, by all means, we would love to hear from you. I think our other listeners would appreciate hearing from you as well. I know they would. The number is area code 304-658-3333. That's area code 304-658-3333. My personal email address, if you'd like to send me an email, I'd be honored to read your email and to do the best I can to respond to it in a way which does credit to the time that it took you to compose the initial email. My email address is waobrien906@gmail.com. That's waobrien906, all one word, no punctuation, no spaces or anything else. waobrien906, waobrien906@gmail.com. Just to pick up a little bit where we were yesterday, and maybe we can move on. What I was trying to do yesterday was scope out a number of programs or a number of issues that seemed to be calling for some attention. And there were three, if you recall from yesterday. One of the issues that seems to warrant attention, and that's the issue that we began to address in yesterday's program, is kind of filling in the blanks in the Constitution. And what I mean by filling in the blanks is looking at the decisions, some of the major decisions of the Marshall Court in the early 19th century, with a focus specifically on those particular aspects of the Constitution which lent themselves to an expansion of federal power at the expense of the states, or in the case of Marbury versus Madison, for example, lent themselves to an expansion of the judicial role in government as part of the separation of powers. Because prior to the Marshall Court, if you remember, the role of the Supreme Court in the entire picture was minimal, expected to be minimal at best on the part of most people. And to go back a little bit to the discussion we had last week when we looked at the Constitution and its overall organizational structure, you'll recall that Article 1, which focused on the legislative branch of government, on Congress, is clearly the largest article in the Constitution. Article 2, on the President and the powers of the President, is a little bit less lengthy than Section 1, than the legislative branch article, and it stands to reason that that would be true for two reasons. First of all, the Constitution was designed to replace the Articles of Confederation, which had put total power in the legislative branch, in the people's branch. And it was that particular situation that produced, in the minds of many, the need for a change. And the Constitution, of course, constitutes that change. So it stands to reason that since issues related to the legislative branch of government was more than anything else the cause that precipitated the calling of the Constitutional Convention in the first place, it stands to reason that the article addressing the powers of Congress and the powers of the Senate would be substantially longer than would the other sections of the Constitution. That just makes sense. And the second reason that the Article 2 relating to the executive branch, the powers of the President, would be less is because there was a general expectation at the time of the convention that Washington would be the first president. And many people were less concerned about abuses coming from the executive branch because they were confident that George Washington was going to be the first president, and they expected little problem coming from that branch of government as long as George Washington was alive and sitting in the president's chair, so to speak. So it stands to reason that Article 1 on the legislative branch would be the longest section in the Constitution. And the next one, Article 2, would be substantially less in length, and that was the executive branch. And Article 3 relates to the powers of the judiciary, and it was the shortest of the three. And it stands to reason that, all that basically is in Article 3 of the Constitution relates to the fact that there will be a Supreme Court and as many inferior courts as Congress chooses to create under the Constitution. And then it talks about the appointment of the judges being it doesn't say for life, it says during good behavior, which means that barring their impeachment, they would serve as long as they lived, barring some high crime or misdemeanor, which is the same basis on which the President of the United States can be impeached. And so the point that I was making is that while we did go through the Constitution and look at the various elements of it in terms of its overall structure, its overall makeup and organization, what we needed to do, and we kind of set it up last week when we did this, is to look at those elements, those aspects of the Constitution, particular phrases and particular causes, which became the focus of judicial attention as the courts began to fill in the blank and expand upon the overall meaning and implications of the Constitution. And that was the first issue. We began to address that yesterday, and we'll continue to address that. The second issue, which it seems to me very important, that seems to call for some sort of attention, is the whole issue of corporations themselves. And we began to look at that yesterday when we were looking at the case of McCulloch versus Maryland. And this is in the context of a review of what we did yesterday. And what I wanted to reiterate and make the point and emphasize the point again, because I really think it really merits emphasis, is that while most people look at McCulloch versus Maryland and focus on the fact that it focuses on the constitutionality of the United States Bank, and John Marshall pretty well adopts the same argument in justifying the constitutionality of the bank that Alexander Hamilton used when the legitimacy of the bank was questioned during Washington's administration, when Hamilton's reports out of the Treasury Department were first being introduced. One of the major elements of his financial program was the creation of a United States Bank. And it immediately got a reaction principally from southern states and principally from James Madison and Thomas Jefferson, who at the time was Secretary of State under President Washington, that the Constitution did not give Congress, did not give the federal government the power to create a bank. And Hamilton had made the argument that since Congress did have the power to tax, to raise and equip an army, to regulate trade, and to conduct various other aspects of what a government ordinarily would do, then it would stand to reason that there would need to be some sort of an institution created which would make it possible for Congress to carry out all of these other assigned or delegated powers that it was given under the Constitution. And so Hamilton argued in response to Jefferson that the power to create a bank may not be a delegated power, may not be specifically mentioned in the Constitution, but he pointed out that it was there by implication, that it stood to reason that a bank made perfect sense given the kinds of powers that Congress was specifically assigned. And then Hamilton went directly to the article, to Section 8 of Article 1, which spells out the specific powers of Congress, and focused attention on the last one, which says that in addition to all the other powers mentioned above, Congress will have the powers necessary and proper to carry out its previous power, to carry out the previous powers. In other words, whatever Congress feels is necessary to enable it to carry out its delegated powers, Congress would have the authority to do. That was Hamilton's argument to Jefferson in the 1790s. That was the case that Hamilton made to President Washington, and that was the basis on which Washington ruled in favor of Hamilton's reasoning and basically accepted the legitimacy of the first bank of the United States. But the first bank of the United States was chartered only up until 2011. And in 2011, its charter was allowed to expire, to run out. And during the War of 1812, there was no United States Bank. Once peace was restored with the signing of the Treaty of Ghent in 1815, ending the War of 1812, the new administration under President Monroe immediately began to put forth a program which was very, very similar to the program that Alexander Hamilton had presented in the early 1790s. In other words, a very active role for government in planning out and sketching out the needs in order to promote the economic development and growth of this nation. And one of the areas of attention that Congress wanted in this agenda, if you will, in 1816, was the power to subsidize or to build roads and ultimately canals and ultimately railroads, the idea of internal improvements. And beginning at this time, the federal government undertakes, tremendous economic development initiatives in the process of building a national system of roads, the very most famous one being the National Road. And then later on, this power to support of government support using public money to pay for internal improvements is transferred from roads to canals to railroads. And ultimately what is established is the principle that government has a very viable, a very active, a very visible role to play in the economic development of the nation, and it's the cooperative relationship between government and the private sector that drives economic development in this country. And that principle is laid out first in Hamilton's economic program, which he presents to Congress in the early 1790s upon a request from Congress for an economic program from the office of the Secretary of the Treasury, and that's what Hamilton gives him. The irony, of course, is that this very program is being promoted under President Monroe in 1816 by Jefferson and Madison, the very people who opposed it when Hamilton proposed it in the 1790s. So I think that's the irony here. And the nation trying to operate without a bank, without a national bank, creates real problems for the United States. And a little bit of the history of the period, what happens as a result of that is that the emergence, because there is not a United States bank which is managing the overall economic health of the nation, what we see popping up in state after state are state banks. And of course they don't have to worry about federal control anymore because there's no longer a federal bank, a United States bank. And the result is that the nation is going to go into a terrible depression in 1819, in part because of the over-speculation, the aggressive lending, and the over-speculation of these state banks without any federal control. So that made the creation of the Second United States Bank absolutely a critical factor. But the point that I was making yesterday, and I wanted to reiterate it again because it's absolutely critical that we appreciate this. While everybody focuses on the Marshall decision in McCulloch versus Maryland as the case in which Marshall makes constitutional the United States Bank, the focus on the bank as the focus of the decision is, I believe, somewhat misplaced. The fact of the matter is, the United States Bank is a corporation. And what Marshall's decision in McCulloch versus Maryland does is endorse or render constitutional the right of the federal government to initiate and support corporations on the federal level. What that means is it is establishing the principle, the legal principle in this country, that the federal government has a viable role to play in the economic development of the nation. It doesn't take away the states' rights to create corporations, to have laws of incorporation. What it does is build on that by giving that same power to the federal government. So from here on in, economic development in this country is going to be in large part creating a balance or a symmetry or a cooperative relationship between states and the federal government in order to make certain that economic development in this country is going in the same direction at the same time. It becomes a matter of coordinating the federal role with the state role in the process of creating and subsidizing corporations. And part of that we talked about yesterday, laws of incorporation, is to legally create or limit liability for investors. That when a corporation is incorporated, when it becomes a state-subsidized or state-licensed operation, then what incorporation does is limit the liability of the investors, limit the liability of the company, so that the only risk that the investor is taking is the investment in the company itself. If the company goes bankrupt, so be it. The investment is lost. But nobody has the right to go after the stockholders or the boards of directors or the officers of the corporation and request liability from their personal holdings, whether it be their homes or their savings or their capital property or anything else. In other words, by limiting liability, what government is doing, and of course McCulloch versus Maryland makes it possible for the federal government to do this as well as the states. What government is doing under limited liability legislation is making investment more lucrative by reducing the risk associated with investment. By making possible, later on, states and the federal government begin to give tax breaks in tax laws to corporations. It allows them to hide profit. It allows them to make long-term investment in equipment and to build in the depreciation of that equipment over time. So in a sense, government is doing whatever it can to make free enterprise capitalism work and work well. and laws of incorporation make that possible because they limit liability and thereby create a much less high-risk environment for the investment of capital and the buying of stock in private companies, etc. And so the limiting of the liability, it creates a very positive economic environment. And that's what government's ability to create a corporation does. And what Marshall is doing in McCulloch versus Maryland is not only attesting to the constitutionality of the United States Bank. That's what gets all the attention. But again, we're focusing on the trees rather than the forest. The forest, in this case, is not the bank. The forest is looking at the bank as a corporation. And what becomes very telling and very informative in Marshall's decision is to listen to him discuss the nature of corporations and the power of government to create them. What Marshall is doing is laying out a game plan for a government-managed, government-directed process of economic development in this country. And the reason that this is significant is because, as obviously many of us know, the whole history of this country keeps coming back over and over again to the same question. How much government power ought there to be in the economy, in the private sector? When does government support become intrusive? When does government regulation become negative rather than positive? Government regulation establishes stability in the market. It makes sure that everybody plays by the same rules. It regularizes the process of competition. It allows free enterprise to work to its maximum by establishing rules and laws of stability that make the process much more predictable and much more comfortable for those who invest their private treasure in it, in the person of in stocks and bonds and investment and public securities and all the rest of it. So what you are doing is creating a lucrative investment environment for capitalists, for entrepreneurs. You are creating the opportunity to make big money in this country for those people who have the money to invest in that. It's a process that is very important in the history of this country. It's a process that raises a lot of hackles on the part of a lot of people because not everybody has the capital to play with to invest in this game. In other words, it's a game that usually attracts the few rather than the many because most people don't have the money. Most people have just enough to get by. Very few people see their way clear to have play money that they can use in the investment of stock and all the rest of it. So for a long time in this country, the percentage of citizens in the United States invested in the stock market was very small. And the private sector went out of its way in the late 20th century to rectify that situation by making investment in the stock market much more attractive to more people. So now we have reached a point as we in the 21st century where well above, and I don't know the exact number, but I'm guessing well above 20% of working and retired people in this country are invested in the stock market. Many of them in pension programs and 401ks and all the rest of it. So what they have done is they have bought into the idea that their economic future, especially when they retire, is directly dependent upon a viable, stable, secure stock market. So in a sense, the number of people that own stock in this country, the percentage of people has increased tremendously over the last 50 years. And that is not an accident. because, and you can find evidence to support this on the part of corporate executives and corporate attorneys who are advising meetings of stockholders in large corporations. People who have invested in the stock market do not become socialists. They do not become communists. They do not advocate the redistribution of wealth in this country to the degree that socialists and communists do. And so to those who depend on the market for their livelihood, it becomes a political objective to encourage as many citizens as possible to invest in the stock market. Because the more people there are who invest in the stock market, the less questioning there is of the legitimacy and the morality of free enterprise itself, of the market, of the buying and selling of goods and services. And so in a sense, you get much more acceptance among the general population of free enterprise capitalism when the numbers of people invested in the stock market increases. That's one of the reasons why in the 1920s, for example, corporate America made a conscious effort after World War I to persuade employees, organized union employees, to accept stock options as part of their union contract packages in the 1920s. And the thinking was that if the employees of companies become stockholders in the company, then they have a vested interest in supporting the company and being a much more loyal and a much more committed employee. So this is considered to be good business. It's also a way to stifle and head off the inclination to form unions in companies that don't yet have them. Employees who own stock in the company are much less likely to engage in the organization of unions within that workplace. So what you are doing is you are using the attractiveness of profit to win over the support of those people who are potentially the most likely ones to question what you're doing and how you're doing it. In other words, the way you close the gap between management and labor, between employers and employees, is to find a way to invest employees more in the success of the companies. And if you can persuade employees to accept stock options as part of the contract, as part of the contract package offered to your employees, then what you are basically doing is solidifying a much more positive relationship within your company with your employees. Corporate America sees that in the 1920s, especially under the threat of Bolshevism. The Bolsheviks, Lenin, and the communists have just taken over Russia in 1917. And there's this fear that Bolshevism and socialism and communism and radicalism are going to infiltrate our labor unions in this country. And so employers are desperate to find a way to counteract that. And this is one of the ways they do it. So this begins in the 1920s, almost a century ago, 90 years ago. But in the last 30 to 40 years of the 20th century, this movement takes off again. And probably the person most directly responsible for this is Ronald Reagan. A lot of this happens in the Reagan administration, and a lot of this happens in the Tax Reform Act of 1986 during the Reagan administration. That's the point at which the citizens of the United States become convinced that the way to go is the 401k way rather than the defined benefit packages associated with traditional pensions. This is the point at which a very conscious effort is made to sell employees on the idea that by owning their own retirement package rather than depending on the company for it, then the employee is much more empowered. If he changes employers or changes jobs, he can take his 401k with him. He can carry his retirement package with him as a piece of personal property that he controls. And this becomes very attractive to employees in the 1980s and the 1990s. And as a result, the whole 401k movement in this country takes off. As more and more employees, more and more working people become committed to the idea that the more you are in control of your own retirement, the better off you are. And of course what that means is the more you are in control of it, the less your employer is in control of it. And that's exactly what the employers want. They want to basically end the process of defined benefit pensions, which they see down the road is going to break many companies, break many employees. Because we're seeing right now, many companies can no longer sustain the retirement packages that they gave their employees under union contracts in the 60s and 70s and 80s and 90s. And so the transition begins in the 80s from defined benefit retirement plans, which is pensions, to defined contribution plans, where companies agree to go with the employee and contribute so much to their retirement package. But along with that goes the responsibility over the retirement. In other words, the responsibility becomes the employees rather than the companies. And companies want that. And then the next stage in this, and this happens in the 90s, is public employees are convinced, I'm going to say sold a bill of goods, but I don't want to imply that this is totally negative, because it's not. But public employees are convinced that just as in the private sector, they would be much better off if they owned their own retirement plan. And so what that means is that states and cities and municipalities and county governments who have been paying into traditional defined benefit pension programs for their employees give their employees the option of opting out of the defined benefit pension program and opting in to something the equivalent of the 401k plan. And employees do it. And of course they do that. I think they do this in a very, very questionable way morally. What most people bring home is an offer from their employer that basically says, as of such and such a date, your retirement package will automatically be converted into a 401k, which you will own, unless you make the decision to opt out of that change. In other words, it puts the burden on the employee to not allow this to happen. And most employees don't understand it enough, and most of them go along. And so the result is that not only do private sector retirement programs undergo this tremendous shift from defined benefit pension plans into 401k individually owned retirement packages, but so also in the 90s, public employees begin to buy into this, states begin to buy into this. And the result is that much of the money that employers and state governments and municipal governments especially were required to put into pension programs now becomes investment capital. And what we find is that states begin to play the stock market, and they begin to invest in Dow Jones registered companies, and they begin to buy stock in companies. And so states and municipalities become investors in the stock market. And that's the point when the Dow jumps. I can remember, some of you may remember, when the Dow Jones Industrial Average used to be 600, 650, 700, 1100, 1150. Now, today, it's 15,400. What is the precipitating factor that caused the Dow Jones Industrial Average to jump from the hundreds to the thousands? And it was the influx of the tens of millions of dollars from these public employee retirement packages into the stock market. That tremendous influx of public money into the stock market drives the Dow Jones average up almost overnight. And, of course, all of it's based on the fact that the stock market is a secure investment. And we know from the recession of 2007, 2008, when many people lost 25% or more of their retirement programs, it's not secure. It's gambling. And the fact of the matter is, our employers, our governments, have become gamblers on the stock market with our retirements. And at some point in time, this is going to become an issue, a political issue. It has not as yet. I didn't intend to get into that today, but it seems to lead logically into it. The point I'm trying to make here is the role of government in the entire economic development scenario of this country, and the extent to which these decisions in the Marshall Court are laying the groundwork for that role. And the debate that ensues, of course, is how much government is too much government. Where do you reach the point where government's management and regulation and direction and advice becomes intrusive in regulation and begins to entail a lot of red tape, which holds the market back? And so what you find is that corporations are trying to find ways to break free of government regulation and government control, and that debate goes on and on and on, and we know that it's a major distinction between liberals and conservatives in this country, is the debate over how much government is too much government. And that, the groundwork for all of this, the foundation for all of this, is being laid in these Marshall decisions. So the point that I would make is that this involves much, much more than the constitutionality of the United States Bank. It involves the nature of corporations. It involves the role of corporations in the economic development of this country. And more specifically, it involves government's role in the creation of and support for these corporations. So the cozy relationship between business and government that some people complain about so much is there from the very beginning. It goes all the way back to the mercantilist approach, which is the beginning of capitalism, when the King of England is issuing charters to the Virginia Company and the Massachusetts Company and a group of investors who want to go out and found and establish colonies and search for wealth. And government's willingness to give these businessmen, these investors, these companies charters creates a relationship between business and government which has never been broken. Sometimes it becomes a little bit more strained than it is at other times, but it's never been broken. Because the idea of unregulated free enterprise, where government becomes so small that it ceases to be a factor, it ceases to exist effectively as regulator, is a myth. It's a dream. If that ever happens, it's over. And I think all of us need to appreciate that. So to go back, and this was the last issue that we had in yesterday's program then, is about Marshall's effort to work out the power of government in creating corporations. And Marshall says in McCulloch versus Maryland, we admit, as all must admit, that the powers of the government are limited and that its limits are not to be transcended. But we think the sound construction of the Constitution must allow to the national legislature that discretion with respect to the means by which the powers it confers are to be carried into execution, which will enable that body to perform the high duties assigned to it in the manner most beneficial to the people. Let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited but consist with the letter and the spirit of the Constitution, are constitutional. Therefore, Marshall defines or concludes that the creation of the United States Bank, the creation of this particular corporation, is constitutional. And he is speaking for a unanimous court in this particular opinion. And then he goes to the next aspect of the McCulloch decision, which is the right of the state of Maryland to tax the Bank of the United States. Because since the federal bank is in Baltimore, then the state of Maryland, that has the power to tax, assumes that it has the right to tax this new federal bank. And that's in part what the McCulloch versus Maryland decision is about, is whether in fact a state has the power to tax a federal agency or a federal entity. And this is the point at which Marshall makes the very famous statement that the power to tax involves the power to destroy. He says the argument on the part of the state of Maryland is not that the states may directly resist a law of Congress, but that they may exercise their acknowledged powers upon it, and that the Constitution leaves them this right in the confidence that they will not abuse it. So the state of Maryland is arguing in McCulloch versus Maryland that it has the right to tax the Bank of the United States. But Marshall raises that question and says the power to tax involves the power to destroy. And then he goes on and says the following: if we apply the principle for which the state of Maryland contends to the Constitution, generally, we shall find it capable of changing totally the character of that instrument of the Constitution itself. We shall find it capable of arresting all the measures of the government and of prostrating it at the foot of the states. In other words, if we allow the states to tax agencies of the federal government, then we are giving the states potentially the power to reassume control over the federal government by using their power to tax. Marshall says the American people have declared their Constitution and the laws made in pursuance thereof to be supreme, the supreme law of the land. But this principle would transfer that supremacy, in fact, to the states. If the states may tax one instrument employed by the government in the execution of its powers, they may tax any and every other instrument. They may tax the mail. They may tax the mint. They may tax patent rights. They may tax the papers of the custom house. They may tax judicial process. They may tax all the means employed by the government to an excess which would defeat all the ends of government. That was not intended by the American people. They did not design to make their government dependent on the states. And as we know, that is the major issue between the Articles of Confederation and the new Constitution, is whether, in fact, the federal government remains dependent upon the states, or whether the federal government has constitutional power over the states. And Marshall is using this issue of the United States Bank to render a decision in favor of the power of the federal government. So what he is saying is, not only does the federal government have the authority to create corporations, but states do not have the power to weaken the effectiveness of these corporations by taxing them into oblivion. So in a sense, they become shielded from state taxation. Thereby, they remain agencies of the federal government and, in relatively speaking, in control of the situation. And that is the decision in McCulloch versus Maryland. And if I have to reach a conclusion, we've got about 7 or 8 minutes left in this first hour. If we have to reach a conclusion on McCulloch versus Maryland, let it be that the decision in McCulloch versus Maryland involves a lot more, hell of a lot more, than the constitutionality of the United States Bank. It basically establishes the power of the federal government over the states, and it is using the necessary proper clause and the supreme law of the land clause taken directly from the Constitution in order to reinforce the ruling that the federal government under this new Constitution is intended to be superior to the states. And Marshall is saying, not only is that true legally, not only does the court find that to be true, but he is also saying that is really what the people intended when they created and ratified the Constitution in the first place. So the key is the ratification of the Constitution. By ratifying the Constitution in special conventions of the people in each state, rather than having the Constitution ratified by the states, you are creating a government with power over the states rather than a union created by the states, if that makes sense. If you go to the state governments and give them the authority to ratify the Constitution, then you are basically suggesting that the state government which ratifies the Constitution has more power than the government it creates. But when you go back to, when you come to special conventions of the people in each state, you are going over the heads of the state governments back to the people as sovereign under the philosophy of popular government, popular sovereignty, and the idea that the ultimate authority to create government rests within the people themselves. And granted, the people exercise their sovereignty to create the state governments. But Madison makes the point that by having special conventions of the people, what you have in effect done is go back to the ultimate source of power, which is the people, and they have decided in their wisdom to create a new government superior to the state governments that they created earlier. So what you have done is you have rendered the federal government superior to the states in all the ways that matter. And rather than spell out the very specific nature of all of those powers, the founders or the framers of the Constitution built into it specific phrases and clauses which gave the courts the power to enhance federal power by the way that these particular phrases were interpreted. The supreme law of the land, the necessary and proper clause, the sanctity of private contracts, the idea that no person shall be deprived of life, liberty, or property without due process, the power to regulate interstate commerce, the power over all the affairs relating to all the business or all the affairs relating to the territories of the United States, which is Article 4. What you are doing is giving the federal government the power to create corporations and to manage the overall direction of economic development in this country. You are enhancing the power of the federal government to do that, and you are basically giving the government the leeway to build on those powers with clauses like the contract clause and the commerce clause and all the rest of it. Potentially what you're doing is, if a state tries to interfere with the power of the central government, then the courts can always come back and say, if this is a contract, and if the state government is breaking that contract, then the state government is effectively violating the Constitution. Example, and I'm leading into the next hour. The very famous decision of the Supreme Court, of the Marshall Court, in Dartmouth College versus Woodward, which also was a decision rendered in the year 1819. It's one of the most famous cases in the history of the Supreme Court, Dartmouth College versus Woodward. And the issues that precipitate the case are that Dartmouth College was created in 1769 by the King of England. He gave a charter to the overseers, to the Board of Overseers of Dartmouth College, to create that institution. And in the early 19th century, the Jeffersonian Republican Party had taken over control of the state legislature in New Hampshire. And it stands to reason that while the Federalists still had control of Dartmouth College, it stands to reason that the legislature of New Hampshire would like to take control of the college and make it a public university. Make Dartmouth College public rather than private. And so, in the name of the people of New Hampshire, the state of New Hampshire passes legislation taking away Dartmouth College's independent status as a private institution and making it public. And Dartmouth College goes to court in order to defend its right to remain private and not under political control of the state legislature. And it's one of the most famous cases in the history of American jurisprudence. The lead attorney for Dartmouth College is one of its alumni, one of its graduates, Daniel Webster. And the case argued by Daniel Webster is considered to be one of the greatest arguments in the history of jurisprudence in this country. And it revolves around the contract clause. The Marshall Court argues in Dartmouth College versus Woodward that the initial charter creating Dartmouth College was a contract. And the state of New Hampshire does not have the right to violate the sanctity of a contract under the Constitution of the United States. And so Marshall finds for Dartmouth College and against the state of New Hampshire in its effort to take over control of the college. But again, like McCulloch versus Maryland, the Dartmouth College case focuses usually on Dartmouth College as a college. Marshall focuses on Dartmouth College as a corporation. And so by attesting to or upholding the sanctity of contracts to create private corporations What Marshall is doing is shielding or building up a roadblock to limit the ability of government to control the private sector. In this case, the state of New Hampshire, to take control of a private corporation. It, like McCulloch versus Maryland, is a case that has implications and ramifications way beyond the fact that McCulloch versus Maryland is about the bank, and way beyond the fact that Dartmouth College versus Woodward is about a college. Both of them are about corporations. And Marshall will continue in Dartmouth College to lay out his understanding of the nature of a corporation. And it is absolutely critical to understanding what the real issues here are all about. We are at the top of the hour. Let's pause and take a 4 or 5 minute break, and then we'll come back for our second hour in today's program. I'm Bill O'Brien. We'll be right back. We're back with you for our second hour on today's program on the Virtual Center for the Study of the U.S. Constitution. I'm Bill O'Brien, and if you are just joining us today, welcome to today's program. If you've been with us through the first hour, then you deserve kudos for hanging in there with us. I really appreciate that. I want you to know that. If you'd like to call us, we would love to hear from you. We've been doing this extensive analysis of the McCulloch versus Maryland decision and the ramifications of that decision in terms of the overall relationship between government and the private sector under the Constitution. And if you'd like to weigh in on that subject or other subjects as well, we would love to hear from you. Our area code is 304, and the number is 658-3333. That's area code 304-658-3333. And again, my personal email address, if you'd like to email me directly, is waobrien906@gmail.com. waobrien906, all one word, no punctuation, @gmail.com. And if you are just joining us, then we basically introduced the very famous Marshall Court decision of of Dartmouth College versus Woodward just prior to the top of the hour, and with the idea that we would be going into that particular decision during this hour. Again, I believe I said this yesterday, and I want everybody to know this. I am totally indebted to the Head On Radio Network, to Bob Kincaid and his people, for allowing me an opportunity to put a program like this on his network. I mean that. This, I believe, is, for me, it's a passion, and I hope that comes through a little bit, because I think it adds to the program, very honestly, if it does. If I appear bored, then I can't expect you to be interested. So I'm hoping that you are able to pick up the passion that I have towards this material. It just absolutely stimulates me to no end. But it's important to recognize the importance of the Head On Radio Network, of the network like this on the Internet in today's world of information overload. There's so much out there, so much information and so much ideological perspective out there. Everybody is selling something. And it's very, very important to try to keep a sense of balance and an understanding as to what's going on. It is absolutely vital that a network like this, that brings positions which aren't readily available out there to the public at large. The purpose of this particular program and the purpose of the network generally is to present a perspective on the overall issues of the day, which is quite a bit different from the perspective of those people who seek gain from a particular point of view on a particular issue or set of issues. In order to maintain balance, in order to ensure that the marketplace of ideas remains a marketplace of ideas, it is absolutely critical that the Head-On Radio Network and the programs that it brings to us remains viable and remains a player in the marketplace of ideas. Because these are very important ideas. They are ideas and perspectives and issues and insights that chances are you're not going to get anywhere else. It is absolutely critical. And with the power of the Internet, and I won't go into details, but it's very obvious that when we talk about the power of the Internet, we're talking about literally the ability to topple regimes and countries and kings and emperors and military dictatorships and everything else. We are talking about a communication capability, the Internet, whose ramifications and impact we are just beginning to appreciate. It is absolutely vital that we maintain a sense of balance and proportion, and that all relevant perspectives and positions are introduced into the market, into the consideration of the nation's population and the world's population. And the Head-On Radio Network does that, and it's absolutely vital. If you go to the Horn, the Head-On Radio Network website, you will see a PayPal opportunity there. And if you are inclined to appreciate the value of this program or the other programs that the Head-On Radio Network makes available to us, then I encourage you to do whatever you can to keep a network like this and programs like this on the air. I appreciate it. I know Bob appreciates it. More important, I think our nation appreciates it as well. Let's take a look, a little bit more detailed look at McCulloch versus Maryland. No, excuse me, I'm done with McCulloch versus Maryland, aren't I? Good Lord. Senior moment, but I have more of those all the time. Dartmouth College versus Woodward. I love this case. I love the fact that Daniel Webster argued this case. And, of course, the famous stories when he was making his concluding remarks before the Supreme Court. The word is that that a tear came to Daniel Webster's eye. So passionate did he become in the defense of the independence and freedom of his alma mater. I don't know that many attorneys that shed tears, but I guess if anybody's going to do it, Daniel Webster's as good as anybody. So we looked at the issues that precipitated the case of Dartmouth College versus Woodward. A charter issued by the king to the trustees of the college in 1769, before the Revolution, before independence, and Marshall's position that to terminate that charter is to violate a contract. And state governments are not allowed under the Constitution of the United States to invalidate the sanctity of private contracts. Whatever the rationale, whatever the seeming justice and legitimacy of the action, the fact that the legislature had come under the control of Jeffersonians, the fact that what is called one of the most famous historians, Peterson, Jeffersonian historians referred to as the Jeffersonian persuasion, the fact that it had taken the country by storm, and the fact that the vast majority of citizens in this country in the early 19th century had shifted from rather distant, impassionate support of the Federalist position to the much more passionate Republican, Jeffersonian Republican position, that didn't justify, in Marshall's eye, in Marshall's thinking, the right of the state to violate a contract and to take over control of this little college. So that's the background. That's the case. And so let me just share with you a couple of what I think are relevant passages. Marshall begins by reiterating the creation of the charter. And in 1816, on the 27th of June, the New Hampshire legislature passed an act which effectively took over control of Dartmouth and made it a public institution rather than a private one, under a piece of legislation entitled An Act to Amend the Charter and Enlarge and Improve the Corporation of Dartmouth College. The legislation itself refers to Dartmouth College as a corporation. It is absolutely imperative that we not lose sight of that. Because just as McCulloch versus Maryland has tended in the minds of most people to be a case about the bank and not a case relating to corporations, so Dartmouth College versus Woodward has become a case about a college rather than a case about corporations as well. But Marshall's first point, his first challenge, is to equate the charter with a contract. What he has to do is essentially make the case that the original charter for Dartmouth College is a contract under the Constitution. And he goes on to say that that's somewhat obvious. He says, it can require no argument to prove that the circumstances of this case constitute a contract. An application is made to the Crown for a charter to incorporate a religious and literary institution. In the application, it is stated that large contributions have been made for the object, which will be conferred on the corporation as soon as it shall be created. The charter is granted, and on its faith the property is conveyed. Surely, in this transaction, Marshall says, every ingredient of a complete and legitimate contract is to be found. And then Marshall raises questions. Is this contract protected by the Constitution of the United States? And secondly, is that contract impaired by the acts under which the defendant holds? In other words, is the charter a contract? And he says it is. And then his next point is, if indeed it is a contract, is it a contract under our Constitution? That's his first challenge. And the second challenge is that contract impaired by the legislation in New Hampshire that makes this a public institution? Is the original object of the charter, of the contract, violated by the act of the New Hampshire legislature? And obviously his answer to that is going to be yes. He makes the point about, and he goes directly into the idea of the original creation of the college, which is, I point out to you, an act of incorporation. It is the creation of a corporation. And Marshall says, if the act of incorporation be a grant of political power, if it create a civil institution to be employed in the administration of the government, or if the funds of the college be public property, or if the state of New Hampshire as a government be alone interested in its transactions, the subject is one in which the legislature of the state may act according to its own judgment. In other words, if all of these things were true, if there was political power associated with the college. Now, we know in today's world that there's tremendous power associated with colleges and universities. We know the size of the endowments of some of these in the billions of dollars, the Harvards and Stanfords and all the rest of them. But what Marshall is saying is if there was political power associated with the creation of this college, if the college was to be employed in the administration of the government, if the funds of the college were to be public funds, tax money, or if only the state of New Hampshire was interested in the college, if all of these things were true, then New Hampshire would have the right to run it. It stands to reason, because the state of New Hampshire, the government of New Hampshire, is the agent created by the people of New Hampshire to carry out its will in political matters. But then Marshall goes on and says, but if this be a private eleemosynary institution, education, colleges are usually referred to as eleemosynary institutions, and that means basically education institutions, not for profit, not for political power, but education. If this be a private eleemosynary institution, Marshall says, endowed with the capacity to take property for objects unconnected with government, whose funds are bestowed by individuals on the faith of the charter, if the donors have stipulated for the future disposition and management of those funds in the manner prescribed by themselves, there may be more difficulty in the case. Basically what he says then is Dartmouth College is really endowed by private individuals. It is then, he says, an eleemosynary, and as far as respects its funds, it is a private corporation. So what he has done is he has established that the charter is a contract, and then he has gone on to establish the fact that this contract creates a private corporation rather than a public one. And of course what he is doing is building the legal case to basically rule against the state of New Hampshire's efforts to take over control of this college. Then he says, education is an object of national concern and a proper subject of legislation. All admit that. But is Dartmouth College such an institution? Is education altogether in the hands of the government? Does every teacher of youth become a public officer and do donations for the purpose of education necessarily become public property? What Marshall is doing is laying out the legal groundwork for the fact that the state of New Hampshire does not have the foundation, the basis, to make its claim of takeover legitimate. Dartmouth College is private. Every teacher in it is not a public employee. It is not a public officer. It's not a government employee, and therefore the purpose of education is not in and of itself public property. Whence then can be derived the idea, he says, that Dartmouth College has become a public institution and its trustees public officers exercising powers conferred by the public for public objects. In other words, Marshall has effectively shot down every basis for a takeover by the state of New Hampshire. It is not public. It is not built with public money, public tax money. Education is not public. The teachers in the institution are not public employees, etc., etc., etc. So what he has done is he has severed every potential connection, every potential cord that would link Dartmouth College to some aspect of government control. And what he is left with is the idea that it is exclusively private, its money is private, it was raised for private purposes, it does not exercise political power, its faculty are not public employees, etc., etc., etc. Therefore, to do anything with this by the state of New Hampshire, by the state government of New Hampshire, would be a violation of the original contract. So what Marshall is doing here is he is validating, he is emphasizing the absolute critical nature of contracts. We know here at the Virtual Center, because we've covered it, we know that one of James Madison's major concerns about the Articles of Confederation was the extent to which state governments were engaged in the process of violating contracts. Private debts, public taxes. The states were passing stay laws and installment laws and a variety of other direct interferences with private contract. So it's very obvious that if the Constitution is going to fix what the founders who wrote it wanted it to fix from the Confederation period, then the idea of the sanctity, the absolute inviolability of private contracts had to be emphasized. This particular case is perfect to make that case for John Marshall. No longer will a state be able to interfere with a private contract after this decision in Marshall's thinking. Then he goes through into the issue of Dartmouth College as a corporation. And this I want to share with you, if I can. So if you'll bear with me, I'll do the best I can, because I'm reading an awful lot of legal language here, and I apologize for that. Marshall says, a corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. A corporation is an artificial being. It's invisible, it's intangible, you can't put your arms around it, you can't hold it. It exists only in contemplation of law. Being the mere creature of law, Marshall says, it possesses only those properties which the charter of its creation confers upon it, either expressly or as incidental to its very existence. In other words, because of its existence as in contemplation of law, because it is a creature of law, its properties are limited to whatever is in the original charter which creates it. He said, among the most important of these properties are immortality, and if the expression may be allowed, he says, individuality. Properties by which a perpetual succession of many persons are considered as the same and may act as a single individual. Basically, what Marshall is doing here is defining the nature of a corporation. We need to focus on this definition because this definition is the basis on which the Supreme Court in 2010, in the case of Citizens United, finds for corporate rights to make political contributions to political campaigns. The argument that Marshall is going to make here is that to deny corporations the rights of persons is to deny the individual citizens that make up the corporation their individual rights to operate as persons. What Marshall is arguing here is the rights of the people who make up the corporation transferred directly to the corporation itself, And it's not going to be that much of a stretch to basically argue that if individual people need the protection of the Bill of Rights, so also do corporate persons need the protection of the Bill of Rights. And one of the rights that persons are entitled to under the First Amendment is the right to free speech. Our entire political system can only function when there is a free exchange of ideas, when the marketplace of ideas is allowed to work. Free speech is critical to the very nature of our political system. Persons must have it. But Marshall is laying the groundwork here for saying, so also must corporations have that right. This may be more important than the independence of Dartmouth College. This may be a more important part of Marshall's decision in Dartmouth College versus Woodward than the legitimacy of the original contract ensuring the independence and private nature of Dartmouth College. So Marshall says, among the most important properties of a corporation which only exists as a legal creation are its immortality and its individuality. These are properties by which a perpetual succession of many persons are considered as the same and may act as a single individual. What he's basically doing here is laying out the ingredients of corporate personhood. They, meaning these properties of immortality and individuality, they enable a corporation to manage its own affairs and to hold property without the perplexing intricacies, the hazardous and endless necessity of perpetual conveyances for the purpose of transmitting it from hand to hand. It is chiefly for the purpose of clothing bodies of men in succession with these qualities and capacities that corporations were invented and are in use. Let's listen to this one again. Let's see if we can basically comprehend what Marshall is saying here. The properties of immortality and individuality, which mean that a perpetual successions of persons are always considered to be the same, the corporation, and that they may act as a single individual. It becomes a person. They enable the corporation to manage its own affairs, hold property without all the intricacies and the endless necessity of perpetual transfers from one hand to the other. It is chiefly for the purpose of clothing bodies of men, he says, in succession with these qualities and capacities that corporations were invented and are in use. The reason for a corporation is to make it possible for an endless succession of persons to continue to act as one person. By these means, a perpetual succession of individuals are capable of acting for the promotion of the particular object like one immortal being. But this being does not share in the civil government of the country, unless that be the purpose for which it was created. In other words, if the corporation is private, if the contract creates a private corporation, then that means that government doesn't have a right to interfere with it. And he's building the case here for the college, but he's doing more than that. Because the person that is the corporation is created and can act like one immortal being, that doesn't mean that it becomes part of the civil government of the country unless that's in its original charter, in its original contract. Its immortality no more confers on it political power or a political character than immortality would confer such power or character on a natural person. Because a corporation is immortal and it's transferred from person to person in succession, all of whom can act as one person, that doesn't mean that that person becomes, that like a natural person, that a natural person becomes immortal. It is no more a state instrument, Marshall says, than a natural person exercising the same powers would be. You can't turn a corporation into a natural person, is what he's saying. If then a natural person employed by individuals in the education of youth, or for the government of a seminary in which youth is educated, would not become a public officer or be considered a member of the civil government, how is it that this artificial being created by law for the purpose of being employed by the same individuals for the same purposes should become a part of the civil government of the country? If you can't do this with an individual person, what makes you think you can do it with a corporation, is what he's saying. What he is saying is the government doesn't have the right to take over control of individual persons. What makes it think it has the right to take over the control of a corporate person? So he is engaging in a little bit of negative logic here. He's leading you to the conclusion that it doesn't make, what the state of New Hampshire did doesn't make sense. Therefore, you have no choice but to go along with the decision he's going to make. The reasoning here is powerful. It is incredibly deep and incisive. Because the government has given it the power to take or to hold property in a particular form and for particular purposes, has the government a consequent right substantially to change that form or to vary the purposes to which the property is to be applied? Marshall is basically saying that even though the government created the corporation, it doesn't have the right to control it. The objects for which a corporation is created. Now again, he's defining a corporation. The objects for which a corporation is created are universally such as the government wishes to promote. They are deemed beneficial to the country, and this benefit constitutes the consideration, and in most cases the sole consideration, of the grant. In other words, is the creation of the corporation in the public interest? He doesn't use that phrase, but that's what he means. If the corporation serves the public interest, if the public welfare, the general welfare, will be promoted by its creation, by its existence, then that becomes the sole consideration of the grant. In most eleemosynary institutions, Marshall says, the object would be difficult, perhaps unattainable, without the aid of a charter of incorporation. So what Marshall is saying here is that a corporation's primary reason for existence, the reason that government has the power to create a corporation, is because that particular corporation will serve the public interest. And that's government's responsibility under the Constitution. In the preamble to the Constitution, part of its responsibility is to promote the general welfare. So if the existence of a corporation is deemed to be in the public interest, part of the promotion of the general welfare, then that becomes the sole justification for the right of government to create the corporation, but that does not give government the right to control that corporation. is what Marshall is saying. The benefit to the public is considered as an ample compensation for the faculty it confers, and the corporation is created. If the advantages to the republic, if the advantages to the public constitute full compensation for the faculty it gives, there can be no reason for exacting a further compensation. If the creation of the corporation fulfills the purpose for which it was created, then that's all the power that government has, is the ability to create it, not the ability to control. So what Marshall has done is he has legitimized the right of government to create corporations when that corporation is created for a specific something that will be in the public interest, that will be to the good of the public. And the fact that it was created as a private institution by contract means that government cannot control it. In fact, to allow government to control it would violate the original contract which created it. From the fact, then, that a charter of incorporation has been granted, nothing can be inferred which changes the character of the institution or transfers to the government any power over it. The character of civil institutions does not grow out of their incorporation, but out of the manner in which they are formed and the objects for which they are created. The right to change them is not founded on their being incorporated, but on their being the instruments of government created for its purposes. He is establishing the right of corporations to protect themselves from too much government interference. He is establishing the independence of corporations from political control, from government control, from the people's control. Think about this. From the fact, then, that a charter of incorporation has been granted, nothing can be inferred which changes the character of the institution or transfers to the government any new power over it. The character of civil institutions does not grow out of their incorporation, but out of the manner in which they are formed and the objects for which they are created. Whatever the corporation is designed to do needs to be in the original corporate charter. And if it's approved, then it is entitled to remain free of government control to carry out the purposes for which it was created. And the mere fact that government creates it by law does not give the government the power to control it by law or to change the contract under which it was originally created. So what he has done is, in this particular case, as in McCulloch, is not only to rule on the independence of Dartmouth College, but more important, he has laid the groundwork for a definition of corporations which defines very specifically what government's power of incorporation involves and what its power of incorporation does not involve. If this is to be a government agency, if it is to carry out the will of government, that must be in the original charter. If it's not, then government doesn't have the right to violate the contract in order to bring that reality about. I have to say that in combination with McCulloch versus Maryland, this Dartmouth College case is potentially one of the most important political, judicial decisions that this country has ever experienced. Because there's no question that what is born here, and its only beginning, are the seeds of the right of corporate personhood. The idea that a corporation is created to be immortal. And as it passes from people, as a succession of persons continues to come and go, every one of the new persons is entitled to act the same way that the previous persons acted, because the corporation assumes the power of the people that comprise it. And therefore, if a person, a natural person, has rights, so also does the corporation, which is the legal creature that assumes that same definition of personhood. Think about what this does for corporations. Think about what this does for private corporations and boards of directors of private corporations when government begins to demand information, or when government seeks to regulate or oversee the behavior and the operations of these corporations. I think it is absolutely incredible what we are experiencing here. I think something else. I think that those people who are most put out, upset by the Citizens United decision of the Supreme Court in 2010 are missing the boat. Because what they seek to do is challenge the idea of corporate personhood in the Citizens United decision of the Roberts Court. But the idea of corporate personhood goes all the way back to the initial definition of the powers of corporations under the Constitution in the decisions of John Marshall. Marshall is laying the groundwork here for corporate power in this country and corporate independence from government control in this country that become incredible, incredibly important. And so it seems to me that the principle of corporate personhood is established in this country long before the 14th Amendment, long before Thaddeus Stevens gets up in the United States Senate and testifies that corporate personhood was part of the intent of the 14th Amendment. Most of us grew up believing, most of us who went to school and took history and government classes were led to believe that the purpose of the 14th Amendment was to protect the rights of ex-slaves by basically making them citizens, by declaring that they are legitimate legal persons under the Constitution of the United States. And as such, their rights could not be violated without due process of law any more than could the rights of whites. That's what I always thought the 14th Amendment was about. But Thaddeus Stevens, who sat on the Reconstruction Committee that drafted the 14th Amendment, testified that the drafting of the 14th Amendment was done with full realization that corporations would have the same rights of personhood as would the ex-slaves. In fact, the story goes that he waved a piece of paper around and said, "I have right here proof from the minutes of that meeting that when the 14th Amendment was drafted and when confirmation was made of rights like privileges and immunities, the same privileges and immunities as every other citizen and all the rest of it, the intent was to give these rights to corporations as well as to ex-slaves." It is not an accident that the majority of cases that come before the Supreme Court in the late 19th century under the 14th Amendment are not race cases. They are business cases. They revolve around the rights of corporations to remain independent of government control. And this idea of corporate personhood goes all the way back to the Marshall Court in 1819 with the decisions of McCulloch versus Maryland and Dartmouth College versus Woodward. So again, the McCulloch versus Maryland decision does a hell of a lot more in the history of this country for the meaning of the Constitution than legitimize the constitutionality of the United States Bank, which is what all the history books tell us it's about. The Dartmouth College case does a lot more than simply validate the independence of Dartmouth College by ruling that the original charter which created it was a contract, and then to violate that charter was to abrogate the sanctity of contracts, which is a violation of the Contract Clause of the United States. So what Marshall has done in these two decisions, just these two, he has drawn attention to the Contract Clause, to the Supreme Law of the Land Clause, to the Necessary and Proper Clause, as ways to enhance the power of the federal government over the states and the independence of corporations from government control. So in a sense, what we see here is something very important politically going on. The concerns that Madison had in the vices of the political system of the United States, the document he wrote in 1787, which laid out his major concerns about the Articles of Confederation, are being addressed in these court decisions. What the Supreme Court is doing is filling in the rights and the powers of government. And what Marshall has said in McCulloch versus Maryland is that by definition, a constitution cannot prescribe every single power, every single action that government is empowered to take. Marshall says that if you set out to do that, you do not have a constitution, you have a legal code, a code of laws. And by definition, he says, a code of laws is so huge and so complex that the mind of the average citizen cannot even begin to comprehend the detail that it contains. The beauty of a constitution, Marshall says, is that it leaves much of the power that government will have to inference and interpretation, to the idea of implied powers. I would argue that these Marshall decisions validate the concept of a living constitution in ways that most of those who try to defend the idea of the living constitution have not yet hit upon, have not yet discovered. Most of those that I've seen who try to defend the idea of a living constitution, the idea that the Constitution changes as society changes, and that's the only way that the Constitution can remain relevant and up to date, is by interpreting new powers to address new challenges and new situations. And if you deny government that flexibility, that power to adapt then you kill it. Because the only alternative then is to continually pass amendment after amendment after amendment to address new situations and new challenges. And Marshall says if you do that, you've ceased to have a constitution and you've replaced it with a code of laws. And that's not what the people of the United States ratified in 1787, 1788. What Marshall is saying is that the people, in their wisdom, ratified a constitution whose power, a government, that would create a government whose powers would constantly be reevaluated and updated by interpretations, by inference, by implication, by looking at relevant places in the Constitution where additional powers can be conferred and existing powers can be altered or deleted. And that's the way a constitution remains a constitution and stays relevant. That's the best argument for the living constitution that I've ever seen. Those, and I started to mention this before and I got a little bit sidetracked. Most of the defenses of the Constitution, of the living Constitution that I've seen, focus on the Ninth Amendment. The Ninth Amendment to the Constitution The Ninth Amendment to the Constitution of the United States says that the specific mention of delegated specific powers in the Constitution does not mean that that's all there are. That there may be rights added as time goes on. Most of the defenders of the living Constitution focus on the Ninth Amendment as being the principal justification for the idea of a living Constitution. But I would argue that the best defense for the concept of a living Constitution are in the rulings of John Marshall himself. The foundation is laid for the development, for the beginning of the development of this country, the economic development of this nation, through the idea of directed, regulated, free enterprise capitalism. And it absolutely requires the creation of corporations. Government must have the power to create corporations because by definition a corporation is created to serve a particular public need. And the mere fact that government has the power to create them does not mean that government has the power to control them. And so what you are establishing here is the legitimacy of corporations as well as the relative independence of those corporations from political control. My God, is this important. I think it's absolutely, vitally important to understanding the Constitution of the United States. And we have reached the end of our program today. It is 58 minutes after the hour. I want to thank you for being with us today. I invite you to be back with us tomorrow. And I believe tomorrow we'll get into our friend Charles Beard, and let's look at a little bit of his criticism of the Constitution Convention and the framers who wrote the Constitution as being self-interested, racist, sexist, property owners, etc. Let's take a look at that tomorrow. I hope that you have a wonderful evening and that you are safe. I invite you to stay tuned to the Head On Radio Network to join Bob Kincaid in just a moment. This is Bill O'Brien. Thanks for being with us. Be safe.